We are answering the question whether the 2017 presidential election was conducted in accordance with the principles laid down in the Constitution and the written law relating to elections. In paragraphs 12 and 13 of the petition, the petitioners allege that in the conduct of the presidential election, IEBC became a law and institution unto itself, and so flagrantly flouted the Constitution and the written law on elections that in the end, it completely subverted the will of the electorate. In particular, the petitioners urge that the first respondent violated the constitutional principles set out in Articles 81 and 86 by failing to ensure that the conduct of the elections was simple, accurate, transparent, verifiable, secure, and accountable. In support of their case, the petitioners filed several affidavits setting out what, in their view, were egregious irregularities and illegalities, which taken together establish an impregnable case on both limbs of the section, to wit, non-compliance with constitutional principles and the written law on elections, as well as commission of irregularities which affected the results of the elections. We shall address other illegalities and irregularities later, but for now, we shall limit ourselves to the question of transmission of results and transmission of unverified results. The petitioner's major complaint in this matter relates to the transmission of the election results. Olekina, Godfrey Osotsi, and Olga Karani, who were NASA's agents at the National Tallying Center at Bomas of Kenya, deposed that hardly 10 minutes after the polling closed at 5 p.m. on the 8th of August 2017, the presidential elections results started streaming in and were beamed on TV screens at the center without any indication of where they were coming from. On inquiry, IEBC kept fumbling around, alleging that because of network challenges, images of Forms 34A were not coming in as fast as would be expected, and that some might not come in at all. Olekina deposed that by the end of 10th of August 2017, IEBC had supplied them with only 23,000 Forms 34A and 50 Forms 34B. By the time the results were declared on the 11th of August, the results from over 10,000 polling stations had not been received. In these circumstances, he wondered how the final results declared could be relied upon to validate the election. The petitioner's further case is that the results that were streaming in from the 8th of August 2017 to the 11th of August 2017 showed a consistent difference of 11% between the results of Uhuru Kenyatta and Raila Odinga. According to the petitioners, such a pattern indicated that the results were not being streamed in randomly from the different polling stations, but that they were being held somewhere and adjusted using an error adjustment formula to bring in a predetermined outcome of the results. In a nutshell, the petitioner's claim in this regard is that on consideration of the evidence contained in all the affidavits sworn in support of the petition and the submissions made by their counsel, IEBC's conduct of the presidential election was fundamentally flawed and or incompatible with the electoral values and principles of the Constitution, including transparency, accountability, accuracy, security, verifiability, and efficiency. They further argue that contrary to Section 39, 44, and 44A of the Elections Act, IEBC failed to transmit or to promptly and simultaneously electronically transmit presidential election results from the polling stations to the constituency tallying centers and the national tallying center. According to them, this failure was deliberate, systemic, and systematic. The petitioners add that IEBC's Secretary and CEO, Ezra Chiloba, is on record as admitting that as at 17th August 2017, 9 days after the close of the polling, the IEBC was yet to provide all Forms 34A and Forms 34B to the petitioners. And that, bearing in mind that the mischief sought to be cured by the prompt electronic transmission of results and the constitutional obligation of secure, accurate, verifiable, accountable, and efficient elections, the unreasonable delay in the electronic transmission of the results, if at all, as required by Section 39(1)(c) of the Elections Act, grossly affected the integrity and credibility and validity of the results purportedly declared by the IEBC, so the petitioners contended. In response, the first and second respondents submitted that upon completion of counting of votes, the presiding officers would, using the KEMS, take an image of Form 34A, manually enter into the KEMS the result of each candidate, and then simultaneously transmit the image and the results directly to the NTC and to the CTC. The first and second respondents' case, as contained in James Muhati's affidavit, is also that the transmission of results required 3G and 4G mobile network, which was provided by 3 mobile network operators, Safaricom, Airtel, and Telkom Orange. That following a mapping exercise carried out by the first respondent and analysis by the MNOs, the mobile network operators, he does not say when this was done, it was ascertained that about 11,155 polling stations within the country were not effectively covered by either 3G or 4G network. In that regard, it was their case that the presiding officers in such affected polling stations would then be required to move to points with network coverage, or in the alternative, to constituency tallying centers in order to transmit the results. The first and second respondents further urged that even if the electronic transmission of results was not effective as pleaded, the Forms 34A were still physically delivered to the CTC in accordance with the law. They also maintained that the system was not compromised and the results were not in any way manipulated. In conclusion, the respondents urged that the flaws in election transmission of results, if any, cannot be the basis of voiding a presidential election with such a large margin of difference of numbers between the 2 leading contestants. Counsel for the respondents, the second interested party, as well as the first amicus curiae, the Attorney General, submitted that in an election petition, the paramount consideration is to ensure that the will of the majority of the voters carry the day. In their view, flaws in election results transmission cannot be the basis of avoiding a presidential election with such a large margin in votes as the one in this case. On our part, having considered the opposing positions, we are of the view that the contentions by the first and second respondents ignore two important factors. One, that elections are not only about numbers, as many, surprisingly, even prominent lawyers would like the country to believe. Even in numbers, we used to be taught in school to arrive at a mathematical solution. There is always a computational path one has to take, as proof that the process indeed gives rise to the stated solution. Elections are not events, but processes. As Likot JF opines, quote, elections are not isolated events, but are part of a holistic process of democratic transition and good governance, unquote. Incidentally, IEBC's own election manual, what they call the source book, recognizes that an election is indeed a process. There are many other authorities which speak to this proposition. In Kanyalal, Omar versus Trivedi and others, and the Union of India versus Association for Democratic Reforms and another, the Supreme Court of India, for example, stated that the word election is used in a wide sense to include the entire process of election, which consists of several stages, and it embraces many steps, some of which may have an important bearing of the result of the process. These stages include voter registration, political party and candidate registration, the allocation of state resources and access to media, campaign activities and the vote, the count, tabulation, and the declaration of results. Lady Justice Georgina Wood, the former Chief Justice of Ghana, made the same point and added over stages where she stated, and I quote, the election process is not confined to the casting of votes on an election day and the subsequent declaration of election results thereafter. There are a series of other processes, such as the demarcation of the country into constituencies, registration of qualified voters, the registration of political parties, the organization of the whole polling system to manage and conduct the elections, ending up with the declaration of the results and so on, unquote. According to the European Human Rights Committee, the process also includes the right to challenge the election results in a court of law or other tribunal. Here in Kenya, the issue of elections as a process was discussed in the case of Karanja Kabage versus Joseph Kiuna Kariambegu Nganga and two others, where the High Court had the following to say, and I quote, an election is an elaborate process that begins with the registration of voters, nomination of candidates to the actual electoral offices, voting or counting and tallying of those votes, and finally, the declaration of the winner by gazettement. In determining the question of the validity of the election of a candidate, the court is bound to examine the entire process up to the declaration of results. The concept of free and fair elections is expressed not only on the voting day, but throughout the election process. Any non-compliance with the law regulating these processes would affect the validity of the election of the Member of Parliament, unquote. This case was cited with approval by this court in the matter of the gender representation in the National Assembly and the Senate. Therefore, the process of getting a voter to freely cast a vote, and more importantly, to have that vote count on an equal basis with those of other voters, is as important as the result of the election itself. It is also a fact of common notoriety that there were serious protests following the declaration of the 2007 presidential election results. The violence arising from those protests not only claimed over 1,000 lives and led to the destruction of and the looting of property worth hundreds of millions of shillings, but also drove the entire country to the precipice of destruction. It is also common knowledge that following that violence, the government formed the Independent Review Commission, commonly known as the Kriegler Commission, to inquire into the conduct of the 2007 elections and the cause of that violence. One of the critical areas of that commission's focus was the integrity of the vote counting, the tallying, and the announcement of presidential election results. Here we will let the Kriegler report speak for itself in the following words. I quote, "The accessibility of an election depends very considerably on the extent to which the public feel that the officially announced election results accurately reflect the votes cast for candidates and the parties. It depends, too, on factors such as the character of the electoral campaign and the quality of the voter register, but reliable counting and tallying in a sine qua non if an election is to be considered legitimate by its key assessors, the voters, the system of tallying, recording, transcribing, transmitting, and accounting and announcing results was so conceptually defective and executed, counting, tallying during the 27th to 30th December 2007, and even hereafter, and the announcement of the individual results were so confused and so confusing that many Kenyans lost whatever confidence they might have had in the results as announced. While integrity is necessary at all stages in the electoral process, nowhere is it more important than in counting and tallying," unquote. Among the significant recommendations the Kriegler Commission made related to the use of technology in the electoral process, it recommended as follows, quote, "Without delay, the Electoral Commission of Kenya, ECK, starts developing an integrated and secure tallying and data transmission system which would allow computerized data entry and tallying at the constituencies, secure simultaneous transmission of individual polling station level data to the National Tallying Center, and the integration of this results handling system in a progressive election result announcement system," unquote. Pursuant to these recommendations, the process of integrating technology into the conduct of elections was undertaken, starting with the use of biometric voter registration, equipment to register votes on a pilot basis in the run-up to the 2010 referendum. In the 2013 elections, technology was applied for registration of votes, voter registration, and for result transmission. However, that did not work very well in the 2013 general election, and it was one of the key issues that was raised in the 2013 presidential petition before this court. Consequently, in 2016, the Joint Parliamentary Select Committee on Matters Relating to the Bipartisan Independent Electoral and Boundaries Commission was formed, discussed the use of technology in elections, and made far-reaching recommendations which led to, among others, extensive amendments to the Elections Act to provide for use of technology and also technology-dedicated regulations, the Elections Technology Regulations 2017. These changes, in our view, were meant to realign several pieces of election-related legislation with the principles of the Constitution and the electoral jurisprudence that had been developed by the courts. The cumulative effect of the changes was the establishment of what is now referred to as the Kenya Integrated Election Management System, the KIEMS. Henceforth, technology would be deployed to the process of voter registration, voter identification, and the transmission of results to the constituency and to the National Tallying Center. Towards this end, Parliament enacted Section 44 of the Elections Act, subsection 1 of which provides as follows: there is established an integrated electronic electoral system that enables biometric voter registration, electronic voter identification, and electronic transmission of results. Subsection 3 thereof provides as follows: the Commission shall ensure that the technology in use under subsection 1 is simple, accurate, verifiable, secure, accountable, and transparent. Section 39(1)(c) of the Elections Act then squarely addresses the results transmission aspect of these changes in the law, and it provides as follows: for purposes of a presidential election, the Commission shall, A, electronically transmit in the prescribed form the tabulated results of an election for the president from a polling station to the constituency tallying center and to the national tallying center. B, tally and verify the results received at the national tallying center. And C, publish the polling result forms on an online public portal maintained by the Commission. Regarding the voter register, this court in the 2013 Raila Odinga decision had observed that there was no single voter register, but an aggregation of several parts into one register. To cure this anomaly, Parliament amended Section 4 of the Election Act to provide, as I read, there shall be a register to be known as the Register of Voters, which shall comprise A, a polling register in respect of every polling station, B, a ward register in respect of every ward, C, a constituency register in respect of every constituency, D, a county register in respect of every county, and E, a register of voters residing in Kenya. Section 10(1) of the Elections Act provides that a person whose name and biometric data are entered into a register of voters in a particular polling station and who produces an identification document shall be eligible to vote in that polling station. Parliament also introduced a new section 6A to provide inter alia that the Commission shall, not later than 60 days before the date of a general election, open the register for verification of biometric data by the members of the public at their respective polling stations for a period of 30 days. And 2, the Commission shall, upon expiry of the period for verification specified under subsection 1 above, revise the register of voters to take into account any changes in the particulars arising out of the verification process. 3, the Commission shall, upon expiry of the period for verification specified under subsection above, publish the register of voters online and in such manner as may be prescribed by the regulations. All these legislative enactments have one objective: to ensure that in conformity with the Constitution, elections are free, they are fair, they are transparent, and they are credible. It is important to note the terms simple, accurate, verifiable, secure, accountable, and transparent, and grafted into these provisions are the same constitutional principles in Articles 10, 38, 81, and 86 of our Constitution. We must, in that context, now proceed to determine whether the first respondent conducted the presidential election in accordance with the principles laid down in the Constitution and the law. The mystery of Forms 34A and the conundrum of election transmission. By far the most critical and persistently claimed non-compliance with the law was that the first respondent announced results on the basis of Forms 34B before receiving all Forms 34A. It was also alleged that the results announced in Forms 34B were different from those displayed on the respondent's public web portal. This was contrary to Section 39(1)(c) of the Elections Act. The petitioners also argued that the non-compliance was in violation of Articles 81E and 86 of our Constitution. The non-compliance also went contrary to the Court of Appeal's decision in Minor Kiai. The petitioners also claimed that many results were transmitted from the polling stations unaccompanied by the scanned image of Form 34A, contrary to the provisions of Section 39(1)(c) of the Elections Act as read together with the Sections 44 and 44A of the Act. In response, the first respondent submitted that the difference in the results announced on the forms and the public web portal did not offend any law or regulation in view of the fact that the results in the forms were final, while the results on the public web portal were only statistics. Mr. Nyamodi, counsel for the first respondent, also submitted that in view of the Court of Appeal's decision in Minor Kiai, the system of transmission had to be reconfigured to allow for manual transmission. Counsel explained that the source document that the first respondent relied on to do so was no longer Form 34A, but Form 34B. Likewise, counsel submitted a similar fate had befallen Form 34C in terms of format and structure. Towards this end, counsel informed the court that the original Form 34C, which had contained a Form 34A tally, was reconfigured by the first respondent to exclude that tally so as to conform to the decision in the appellate court case in Minor Kiai. As for the controversy surrounding the electronic transmission of results, Council submitted that such transmission was a mere conveyance belt and nothing more. To this, Mr. Ngatia, Counsel for the third respondent would later add that the electronic transmission with which the petitioner was obsessed was like a matatu and no more. What was important, Counsel urged, was what was conveyed, meaning the results, as opposed to the manner in which it was conveyed, meaning the electronic transmission. The first respondent also submitted that the security features of the Kenya Integrated Electoral Management System was programmed to capture and transmit only one image. In some instances, text data was transmitted instead of the filled and scanned forms 34A. At any rate, argued the first respondent, the omission of untransmitted forms was cured by the uploading of the said forms onto the public portal. According to the IEBC, the transmission of the wrong images did not affect or invalidate the result contained in the statutory forms 34A. Later, it was urged access to the scanned forms was granted to the public through the website. Still on transmission of results, the petitioners highlighted various discrepancies. For instance, that there was transmission of results from slightly more than 11,000 polling stations, other than gazetted polling stations, contrary to Regulation 7. It was also alleged that the streaming of results commenced a few minutes after 5 p.m., being the official closing time for all polling stations. In addition, the petitioners questioned the streaming of results in constant percentages of 54% and 44% in favor of the third respondent and the first petitioner, respectively. The petitioners further claimed that there were numerous discrepancies between the results declared in Forms 34A and those in Forms 34B from various polling stations across the country, contrary to Section 39 of the Elections Act, as read with Regulation 82, thus compromising the integrity of the election. In response, the first and the second respondents countered the accuracy in some of the allegations by providing contrary figures through a number of deponents. However, the said deponents also admitted that indeed there were discrepancies in the results in Forms 34A and Forms 34B spread across the country, but attributed them to human errors, fatigue, and the fatigue of the election officials. They further contended that the discrepancies in question did not in any event affect the result of the election. The first and the second respondents added in further response that the 11,155 polling stations from which the impugned results were streamed were in areas which were not served by the 3G and the 4G network coverage. The petitioner's case and the responses thereto by the respondents have conjured in our minds a puzzle of labyrinthine proportions regarding Forms 34A. In the face of a very clear and unambiguous Section 39(1)(c) of the Elections Act, what went wrong with this critical